I'm still admitting people, so people are still trying to call in.
But it looks like there's quite a few.
Yeah, there are 35 people that called in. Some of them are, there are just numbers indicated and we're not sure who the person is, but.
Hi, this is Terry from South County.
Oh, welcome. Rick, do you know how many total were invited?
Off the top of my head, no. I can get a
Okay.
number for you. So Zuhail might. Any idea?
Still admitting. There are 38 people on the call right now.
It could have been around there. Maybe 40 something were on the email.
Okay. Okay. I guess we'll get started. Happy New Year, everyone, and thanks for joining for the second hospital training. We really appreciate it. Roseanne is also on the call today, and she will be presenting on the actual forms and the birth worksheet and entering information on the system, the river system. So what we're going to do today, because I think repetition sometimes is good, is I'm going to review the PowerPoint that I presented last time, just on the section of the voluntary acknowledgement of parentage. If you recall last time, Polly Crozier from GLAD joined us to give us an overview of the Uniform Parentage Act. We didn't think that was necessary this time because it has been recorded, so if you'd like to see that, you may. But I thought that we would go over my PowerPoint once again, look at the terms and the definitions and some of the new procedures. And then I'm going to turn it over to Roseanne and Zuhail from the Department of Health to actually go through the forms. As some of you know, this last week and this week, we delivered the hospital manual, the forms, and I believe this week, child support delivered the pamphlets to most, or not, if not all, of the hospitals. So we did order about 400 pamphlets so far, and we will be reordering, but I wanted to wait a little bit to see if there were any changes or additions to those pamphlets before we order again. So another thing I just want to assure you of, I've in an email that I sent to you last week, I gave you my personal cell phone number, and you can call me at any time up until May 1st with any questions you have on this. So anything that arises, feel free to call. My cell phone number is 225-9532. So I don't want anyone to be concerned that they may encounter some issues and may not know how to answer them. I am available to you, as is Roseanne Giorgiani. So anytime you have a question, please feel free to call. So at this point, I'm going to ask everyone to mute their phones, and we're going to go through the PowerPoint that I presented on December 4th. I'm admitting 2 more people to this call. We're up to 43. That's fabulous. So happy that everyone was able to join, and I hope we're able to answer all of your questions today and concerns. So Rick, do you want to put up that PowerPoint for me and I can run through that?
Yeah,
quickly?
sure. Let's see. I hope it's the right screen. Hang on. I think good. We're all set. Okay.
Great. Now, should I request control? I'm going to try
Yeah.
this myself.
Let's go ahead.
Except when we get to the form, I'm going to need you to put that up for me.
Okay. You're good.
All right, let me see if this. Okay, except advancing on this is.
So yeah, if you click it now, what happens? It doesn't do it?
No.
Okay.
Maybe I'll just let you do it.
Yeah.
Do it.
I think I might. Okay.
Okay, so I think I already went over that. I will try not to take too much time. with my PowerPoint. Okay, so what has changed with the Rhode Island Uniform Parentage Act, and that is the official name of the Parentage Act. So first of all, the name of the form and the procedure. It's now the Voluntary Acknowledgment of Parentage. It's no longer an affidavit, and so there is no notary. There is a witness provision at the bottom of that. Who can complete the VAP? This is also a big change. A married couple or an unmarried couple, same gender or not, may complete the form. The rights and responsibilities statement, or the notice of rights and responsibilities statement, has changed. You're familiar with this. We'll go over the provisions of that. The rescission process has changed a bit. And brand new, for the first time, we have a denial form that we had to create, and we basically took it from the state of New Hampshire. I think everyone knows that there are 4 states thus far that have passed the Uniform Parentage Act. We are number 4. So we took what we could from our states of California and mostly Vermont, and we used a lot of their forms and took a lot of their advice when doing this. The voluntary acknowledgement of parentage is equivalent to an adjudication, a court order. That's huge. That's a significant change. And the VAP now must state affirmatively that there is no presumed, intended, or adjudicated parent. So we'll get into those definitions in a moment. So who can acknowledge parentage? The person who gave birth, obviously, a person who's the intended parent, the alleged genetic parent, a presumed parent. So let's take a look at these definitions once again. So an intended parent means an individual, whether they're married or not, who wants to be legally bound as the parent of a child. It's no longer about biology or only about biology. It's someone who wants to be legally bound as the parent of a child conceived through assisted reproduction or a gestational carrier agreement. So that's the intended parent. What is an alleged genetic parent? We know that. It's an individual who is alleged to be or alleges that the individual is a genetic parent or possible genetic parent of a child. So that's the mother and the father. Next screen. What is a presumed parent? This has not changed that much from what we know this provision to be. So it's the individual who gave birth is presumed to be the parent, may not be the case, as we know. It's the individual who's married to the person who gave birth, and the child is born not later than 300 days after the marriage is terminated. And it can be terminated through, as we know, divorce, death, annulment, declaration of invalidity, or dissolution. The individual who gave birth and the other individual married after the birth of the child and agreed to be named and was added to the birth certificate. Well, that person would execute the VAP and become the legal parent. The individual resided in the household with the child for 2 years and held themselves out as the parent and assumed personal, financial, and custodial responsibility for the child. When I look at this provision, I think about a common law marriage. It's very similar to how one would prove a common law marriage in Rhode Island. The same procedure will be held regarding a holdout provision or a de facto position. They will present facts to the court to indicate that they're the presumed parent of the child, and a court order will issue from that. As we know, a presumption can be rebutted. It's a rebuttable presumption, and a presumed parent, very important, can become a legal parent by executing a voluntary acknowledgement of parentage. So what's an adjudicated parent? You're talking about court order. A court order issued by the Superior Court or the Family Court. Once that court order is issued, that parent is an adjudicated parent. They've been determined by the court to be a parent. So let's talk about the Voluntary Acknowledgement of Parentage form. It is a new form that we worked on and that I believe Roseanne delivered to all of you within the packet of forms last week. So again, the title is new. It's the Voluntary Acknowledgement of Parentage. It encompasses the word paternity. It is no longer an affidavit. What we wanted to do when we talked about doing this was developing a two-part form. And we really wanted to have the voluntary acknowledgement on the front and the notice of rights and responsibilities statement right on the back of that VAP, similar to what New Hampshire does. I'm sorry, Vermont. But we were unable to do that at this particular time because, as you know, it's a computer generated form from Rivers, and we were unable to get that done. So instead, there's a checkbox that serves as a confirmation that the parties have read the notice. So it's right on the VAP. We'll take a look at that in a minute. And it basically states that the parties have read the notice and they're signing after having read the notice. Again, the form does not require a notary. I know that was a huge issue for hospital staff because over the weekends, there may not be someone who's a notary on staff or during the evenings. So we no longer require that notary. And on the form itself, it now refers to parent 1 and parent 2 instead of mother and father. And this is more inclusive of the situations that we'll be dealing with going forward. Again, you can complete the VAP whether you're married or not, whether you're the same gender or not. And that was a huge barrier for us over the past couple of years. So the next slide, we're going to look at the form itself just to show you, make that a little bit bigger. It's in English, it's in Spanish, and I just want to go to that section that talks about, we understand, it's so hard to see this when it's up here. And
A little bigger.
yeah, a little bit bigger. Okay, if you can go down a little bit more to look at the box that we agree, starting with we agree, a little further down, Rick. This acknowledgement will authorize the entry of the parent's name on the birth certificate. And you see there that it says we agree that we are both the parents of the child who's named in the above certification. And you'll see that it says we have read or have had read to us, because that's the federal requirement. If someone can't read, it must be read to them. The notice regarding the legal rights and responsibilities resulting from signing the VAP provided to you in a separate document. So they're saying here by signing that they read the notice. Again, ideally, the notice would be on the back of the form. We were unable to do that at this time. And at the bottom is the witness signature. It's no longer a notary. I won't go into the other provisions on this form because Roseanne will be doing that, and she'll be explaining to you how to enter that information on Rivers. So we'll just give a general overview of these forms. So the next slide, Rick, we've done that. So, yeah, okay, so who may request a VAP? Again, parents, whether same gender or not, whether married or not, may request a VAP. And the question was asked of why would a married couple, not the same gender, want to fill out a VAP form? Well, for the same reason that a same gender married couple would want to fill out a form. The VAP is equivalent to a court order or an adjudication. So many families want to make sure that they have those documents available to them, especially when they travel. If they have the voluntary acknowledgement of parentage form that's been certified by the Department of Health, that's equivalent to an adjudication. The birth certificate, which indicates that there was a marriage and therefore a presumption, can be rebutted. The adjudication cannot be rebutted. So many families, especially same gender families, want to make sure that they have these documents on them at all times. And I've heard many, many stories during the testimony of on the Rhode Island Uniform Parentage Act of, you know, horror stories about what happened to these people. So they want to make sure that they have this court order with them at all times. If the parties have a superior court or a family court birth order, like we would get in the past, there is no need to complete the voluntary acknowledgement. Why? Because you already have an adjudication. You already have a court order. So there's no need to complete the VAP, which is equivalent to a court order in that scenario. So next slide. So an acknowledgement shall be void. So you have this acknowledgement, which is equivalent to an adjudication. It confers all the rights and responsibilities of a parent. So we don't need the court to ratify the VAP. We never did, but we do not need the court to ratify that. The acknowledgement takes effect on the date of the filing, but it can be void if at the time of signing there's a presumed parent and there's no denial filed. So, for example, there's a presumed parent, the parents were married, the child was born of a marriage, and the birth mother does not reveal that that she was married at the time of birth of this child. And there is no denial filed by that spouse, by that presumed parent. And we later find out that there was a presumed parent. So the VAP can actually be void. This won't involve you, but you should really know about this. Or there's an adjudicated or an intended parent. The acknowledgement could be void. And this is the reason that we have that affirmative statement right on the voluntary acknowledgement form, that notice of rights and responsibilities. They've read it, they understood it, they acknowledge that there's no presumed or adjudicated parent at the time. So next slide, I think we might have the notice, the actual notice. Rick?
Should I put up the actual notice, or do you want to
Yeah,
do
why
this?
don't we do that?
Okay.
So what we did is we made sure that the notice that you've all been using all of this time complied with the provisions of the Rhode Island Uniform Parentage Act. So it hasn't changed that much. The notice still says that, you know, we understand that we're waiving our right to have a court proceeding. We're waiving our right to DNA testing by signing it. They know they have a right to consult with an attorney before signing. They know that there are certain rights and obligations from this. The child has certain obligations and rights, the right to receive Social Security benefits, the right to maybe inherit. The parent has the right to ask the court for visitation or custody. So there are quite a few rights and obligations that arise from this. They're saying that they understand that. They understand that they can provide, this was another huge issue for all of us for the past a couple of years, they can give the child any last name that they select. So that child's full name will be added to the birth certificate. They understand that there is no other, or they're stating that there is no other acknowledged, presumed, intended, or adjudicated parent. So when they're signing this VAP, they are telling us this. They are swearing to this. They are saying that there is no one else that could be the parent of this child. If there is, then the VAP could be void. And they understand that the acknowledgement is the equivalent of a court adjudication. And then we'll go through the process of how do they go about rescinding that VAP? Again, it will not involve the hospital staff, but you should know about this process anyway, just so you're fully informed. So I think we can go skip that. Okay, the denial form is brand new. Again, we took the Vermont form and we accommodated it for the Rhode Island law in our procedure. So who may complete a denial form? A presumed or an alleged genetic parent, if they have not previously acknowledged or been adjudicated. So what may occur, and we think this is likely to occur, if they're aware of this prior to them coming into the hospital. That would be the ideal situation. If all of the forms and the pamphlets could be provided to the birth parent prior to entering into the hospital, they would have knowledge of all of this and they would know that this is an option. So if you have a marital situation, we'll take the typical husband-wife situation, but the husband is not the biological father of this child, and there is an individual in the room with the birth parent who wishes to acknowledge the child. If there is a completed denial form from that presumed parent or that alleged genetic parent, they may move forward with the voluntary acknowledgement of parentage with someone else obviously listed as the parent. But the two forms have to go hand in hand. We cannot have a denial form submitted to vital records without a VAP. It is only allowed if someone is going to, I hate to use the term, but stand in as the parent of that child. So it could be a same gender marriage and that same gender spouse fills out the denial. It could be a situation where it is the not a same gender situation, and the husband may fill out that denial form. But once that denial form is signed and executed, both would be completed and submitted to vital records along with the VAP. So that's that brand new, and I think we have the form. We're going to put that up next. It has instructions that go along with it. And it basically, I think it's
Yeah.
this is the whole packet of forms that the birthing hospitals received. So here you have, the child information, the delivery parent information, and you have the alleged genetic parent or the presumed parent information, and you have an actual statement of denial. This presumed or alleged genetic parent is initialing each of these provisions, saying they have read and understood the instructions provided. They understand they have a right to talk to an attorney, as always. They read the instructions. They understand that this is going to be signed in conjunction with the voluntary acknowledgement form, and it has the same effect as a court ordering that they're not the parent, and therefore the two forms together eliminate their parental rights and the duties for the child. And they're saying, I've not acknowledged before, or nor have I been ordered by a court as the parent of the child. They also understand that they have the right to rescind this denial by starting a court proceeding, just like the rescission for the voluntary acknowledgement of parentage. They can either file a petition, some type of a petition to rescind or a motion to rescind, 60 days after the effective date of this form being signed, or if there's already an ongoing hearing before the court, and I can't imagine that child support would act that quickly, and we would have a child support hearing already taking place before the court, but whichever is the earlier of those two is when this issue can be brought up. And then after the 60-day rescission period that is required by law, they can commence a court proceeding on the basis of fraud, duress, coercion, threat, material mistake of fact, and only 2 years after. So they're signing this form, it's being witnessed, and this is in effect the denial coupled with the VAP would allow another person to acknowledge the parentage of the child. And these are just the instructions that go along with what I just mentioned. So we won't go through those point by point, but we provide the definition in the instructions so that you'll have them handy in addition to being in the hospital manual. Okay, so I'm going to go back to my screens because I think Roseanne will talk about the minor affidavit. Again, the rescission process. So this is new. It's been revised. So the rescission process is a judicial process. This cannot be done at Vital Records. A pleading must initiate this. So I would imagine, and I think the court might be working on a sample petition for rescission that a party can just go to the court and fill out the form and basically say, I wish to petition the court to rescind my voluntary acknowledgement of parentage, or a motion, depending on what the initial filing was all about. So this can be done the earlier of 60 days after the effective date of the acknowledgement, or if there is a hearing already taking place, a child support hearing, for example, and it is already scheduled before the court, and it's earlier than the 60 days, they may have their issue heard before the court during that proceeding. And what is the effect of that rescission? If the court orders a rescission, the denial that former spouse may have filled out also becomes invalid. So the parties would be notified of the rescission. And what does that mean? That means that the presumed parent is now responsible for that child again. So if the court orders or approves the rescission, then the spouse would be, or the presumed parent would be responsible for that child, and we could file a motion for support against that parent. Okay, again, after the challenge after the expiration. So suppose that 60 days has gone by and the individual discovers a year later, the birth parent, parent number one, says to that individual, oh, and by the way, I just want to tell you that you're really not the parent of this child, that I had sexual intercourse with this individual, and he's the father of the child, and he wishes to come forward, etc. So if it is within 2 years after the acknowledgement, and it's based upon fraud, which this would be, fraud, duress, coercion, threat of harm, or material mistake of fact, the court can hear that case and make a decision. So I think the next screen, every person must be made a party to it. So it would be the people who signed the voluntary acknowledgement, the person who signed the denial, everyone would be before the court on this rescission proceeding. When a person signs the VAP or when a person signs a denial, so for example, if a presumed parent signed a denial and then left the state, they actually submitted to the personal jurisdiction of the court for this particular issue. So the court can hear this issue and can have that person participate telephonically or in person for that hearing. Support cannot be suspended during the proceeding. If there is a hearing going on and it's going to last a while, it won't be, there will not be a suspension of support until the issue is decided. And again, the court would have to make the decision whether the legal responsibilities for the child would be suspended. And ultimately, there would be a court order, and that court order would be sent to the Center for Vital Records to amend the birth certificate based upon the outcome. So under the Rhode Island Uniform Parentage Act, there are certain individuals that can commence a proceeding in family court within the 2 years of the effective date. There are times when the court grants a little bit of an exception, like if the person didn't discover the fraud until 2 years later. So the 2 years have gone by, and then the scenario I just described, the birth parent says to the other parent, and by the way, after the 2 years, or the person discovers they are not the parent, the court may permit that proceeding if it's 2 years from the point of discovery. And the court's going to have a hearing and decide in the best interests of the child what to do. So basically in the law, we call the burden of proof clear and convincing. And this may be, very well may be coupled with a support hearing or some type of a contempt hearing. The issue might come up during that procedure. So the two new provisions that we have under the Rhode Island Uniform Parentage Act, thank God, parentage by assisted reproduction is brand new. Finally, we have laws in Rhode Island around this particular procedure. A donor is not a parent for our purposes. Parents can execute the voluntary acknowledgement of parentage in this scenario, and they do not need a written agreement to do so. This is a little bit different than Article 8, which is parentage by gestational carrier. This is also brand new. This is the surrogacy law, and it's really specific about what the agreement must contain. It has the legal rights and responsibilities of all parents involved. The parties must be represented by counsel. They would commence a proceeding and obtain an actual court order. And basically the law says that the family court or the superior court order may issue, but if this takes place after the birth of the child, only the family court can be involved and issue a court order in that scenario. So you at the hospital would receive either the family court order or the superior court order that would be presented, and that would be sufficient for you to complete your paperwork for the birth record and add the parent's name to the birth certificate. They would not execute a voluntary acknowledgement of parentage if they already have a court order based upon a gestational carrier agreement. And I know this was also a huge issue for the past couple of years. For many years, the family court was issuing the so-called birth order. I wish this section said parentage order, but it doesn't. So again, before birth, the superior court or the family court may issue an order for declaring parentage. Over the past couple of years, you received mostly superior court orders because the family court was not issuing these so-called birth orders, pre-birth orders. So you were receiving these from the superior court. That will continue after birth. Now the family court will have exclusive jurisdiction. And basically we envision that parties would file some type of a complaint for parentage, not just a complaint for paternity, and a birth order would be issued before the family court. And the court order would order the Center for Vital Records, much like it does now, to designate the parents of the child on the birth certificate. So what we did is we took samples of the Vermont trifold parentage pamphlet. We also updated that for our law, added a few more sections on that. And this is just a basic trifold with the basic questions that may be asked, by parents of you. And we thought this would be very helpful because it's just a brief trifold with just some quick facts for you to refer to. And then we took our parentage pamphlet, which has a little bit more detail about child support related issues, and we also amended that, and we had those printed up for you as well. So you have two pamphlets that have been delivered to the hospital to help you with this process. And again, I'd like you to just take a look at those. I'd like you to tell us if you'd like to add any more commonly asked Q&A. We can certainly do that. This is why I kept the printing of these to 400 at this point and delivered those to you, because we want to make sure that we have everything that you need to answer these questions. So take your time, look at these, and please let me know if you think that anything else needs to be added. This is the parentage questions and answers. This is the lengthy, I think it's 19 pages, that we also provided to you with all of the updates. So, in the event this is not comprehensive enough, we're happy to change this as well. We want to do what's going to make your life easier and help you do this. So I'm going to turn this over to, I think, Roseanne, to discuss the changes to the system and how you're going to complete the forms, and then we'll answer any questions that you have. So thank you for your time.
Good morning, everyone. Happy New Year. Today I'll be talking a little bit about the hospital staff responsibilities, the marital status selection that will be impacted by a voluntary acknowledgement of parentage, instructions on how to submit a voluntary acknowledgement, the marital statuses that will not be impacted by voluntary acknowledgement of parentage, refusals, the roles of vital records, contact information, and confirmation of identity and eligibility of parent 2. So the hospital staff responsibilities. You'll be required to issue the pamphlets and the notices of rights and responsibilities that Sharon just went over with you to every parent that's requesting to sign a voluntary. You'll provide staff, the staff will provide answers to the questions from those parents. If you don't have the answer, don't panic. We are here to help you with answer the questions. We have Illuminata Corona on our staff who will be answering all general questions. We have Keisha Nelson who will be answering hospital paternity questions. And we also have Zuhail Figueroa who will answer any of the questions regarding this. So please feel free to reach out to them if you have someone at your desk and you do not know the answer to the questions. And of course, you can reach out to me. I can give you my phone number as well. My cell phone number is 401-644-3387. And like Sharon gave you her phone number, you can always reach out to Sharon if I'm unavailable. You will witness signatures on the voluntary acknowledgements. That's different. You will not need to notarize those anymore, which is nice. You have to validate the identification that's provided to you. And then you have to file the birth record with the Rhode Island Department of Health in accordance with state law. So the marital statuses that will be impacted by the voluntary, it's never married PA, married with a denial, just married, but you still want to request a voluntary acknowledgement of parentage, divorced or widowed, 300 days after the marriage is terminated by death, annulment, declaration of invalidity, divorce or dissolution, or marriage, or married separated, 300 days after the marriage is terminated by death, annulment, declaration of invalidity, divorce or dissolution. Now we're going to go over the instructions in Rivers on actually how to complete the voluntary acknowledgement of parentage. There's only a few things that have changed. Zuhail will be bringing that to your attention as we go into this section. Never married, requesting a voluntary. If the individuals were married to each other, they can request a voluntary. This no longer requires a notary, but it must be witnessed. Prior to completing the form, the staff should provide the notice of rights and responsibilities and the pamphlets before the parents sign the voluntary acknowledgement. Never married PA.
To process and never marry PA in reverse, this did not change. You will enter all the information that you normally would enter by selecting the marital status never married PA in reverse. As soon as you enter all the information, you can go to record, print, and then paternity acknowledgement. As soon as you print this form. Go to the next slide. Okay, once the form is printed and signed, it's really important to complete the date PA signed and date PA sent.
Married with denial. The individuals who gave birth to the child and their spouse who were married to each other and the child was born not later than 300 days after the marriage was terminated by death, annulment, declaration of invalidity, divorce, or dissolution. The name of the spouse shall be entered in Rivers unless the denial of parentage form is submitted along with the voluntary acknowledgement containing the name of the person acknowledging parentage. The acknowledged parent's name will be entered into the Rivers system. The denial of parentage form will not be available electronically in the Rivers system. But we did provide a fillable form for you.
Once you get the denial completed form at the hospital, then you can complete the VAP. To process the VAP in Rivers, you're going to complete all the information, selecting the marital status married, and then you will have to check off the checkbox that says with denial. As soon as you do that, Rivers will let you to print a VAP. In order to print, you will have to click record, print, and then paternity acknowledgement. Like we previously said, it is really important that after you print the form, parents sign and you witness this, please complete the date PA was signed and was sent.
Married PA requested. The Rhode Island Uniform Parentage Act now allows married couples, regardless of their gender, to complete a voluntary acknowledgement of parentage. The reason they would do this, because it acts in lieu of a court order. So when they travel and they're in a different state, they have this as backup along with the birth certificate, and then they don't have to worry about any legal problems. It will not be available electronically in Rivers at this time, but we're hoping between the next few weeks to the next 2 months, it will be implemented where you can just check the box where it says married, PA requested. But right now, you're just going to have to do it on the electronic fillable form that Zuhail has provided.
Like Roseanne said, we provided a fillable form that you can use if married couples request to complete a voluntary acknowledgement of parentage. To make it easy for you, we also provided a drop-down list. This is for race and education. Once you complete this VAP, please print, have parents sign in the form, witness, and then send to the Center for Vital Records. Divorce widow PA. This process did not change in Rivers. To create a VAP form in Rivers, you will have to select the marital status, divorce widow, 300 days or more, PA, and then you can go to record, print the PA. Make sure if you choose this marital status that the date and state of divorce is entered prior printing the VAP. Once this is printed, please have parents sign in the VAP. You will witness this form, and the date of PA sent and signed should be entered in Rivers. Married separated PA, again, this process did not change. To create a VAP form, please select the marital status, married, separated, 300 days or more, PA. The date and state of separation should be entered prior printing the VAP. Once you enter all the information, you can go to print. You're gonna click record, print, paternity acknowledgement.
Marital status selections that will not be impacted by the voluntary acknowledgement of parentage. Never married, married, spouse refused, divorced, widowed, 300 days or more, or that's not later than 300 days, and not stated unknown. Refusals, this is not denials. If parents are married and no denial was completed prior to the birth of the child, the spouse's name shall be listed on the birth certificate. Ask for the spouse's full name. If refused, select married husband's info refused, and the marital status in the birth module will print husband's name unknown on the birth certificate. This is also something that is underway to be updated to say spouse's name unknown instead of husband's name unknown. The mother or parent will be required to petition the court to have the husband's name unknown or spouse's name unknown to remove from the record before adding a biological parent. Confirming identity and the eligibility of parent 2. All parents signing a voluntary acknowledgement of parentage must present a valid government-issued ID. It should not be expired longer than 3 years, and this is in accordance to the Secretary of State's notarization policy. Confirm the parent's age. The parent has to be 18 years or older. If parent 2 is a minor, a parental consent form must be completed and witnessed, or an affidavit of minor child acknowledging parentage must be completed and notarized. The affidavit should be used, this affidavit should be used for the emancipated minors. Those are minors living on their own, not under their parents' care, not under their supervision, self-sufficient legally, financially. Returning the voluntary acknowledgement of parentage to the Rhode Island Department of Health. Complete the parentage form. Completed forms must be sent to the Rhode Island Department of Health Center for Vital Records within 1 week of the birth of the parents if the parents are residing in Rhode Island, and 2 weeks if the parents are residing out of state or out of country. Complete date PA signed and date PA sent fields in the birth registration field. That's critical to the PA being released. Attach or file proof of identity for those parents. It can be mailed to the Rhode Island Department of Health, Center for Vital Records, Birth Registration, 3 Capitol Hill, room 101, Providence. The role of the Center for Vital Records. The Rhode Island Department of Health Center for Vital Records receives the completed acknowledgements of parentage by mail. These VAPs are reviewed for completion, which are the signatures, the identification, making sure everything that's recorded in Rivers looks the same as what we're receiving on the actual hard copy. The VAP are compared to the data entered in the electronic system, and the fields must match. If the fields don't match and there's discrepancies, it will not be accepted in the Rivers system and it'll be returned to you. You can, if you have questions about why things are returned, you can speak with Keisha Nelson. She will be more than happy to help you with that. Accepted VAPs are copied and sent to the Office of Child Support Services. The originals are kept on file in the Department of Health in a locked cabinet. Facilities all facilities are not permitted to issue these copies of the signed acknowledgements at your office. You are not allowed to submit, to make copies of those for them. If they request a copy, it is going to be a certified copy that goes along with their birth certificate, and we will actually put the seal on the copy of the voluntary acknowledgement of parentage. If you have any questions, as I mentioned before, please feel free to reach out to Zuhail. Illuminata should be added to this list, which she's not on this list, but it's Illuminata Corona. For all general questions, she can be reached at 401-222-5343. We can send you her email address as well. So do we have any questions?
Maybe we can use that little hand so that when everyone doesn't talk over each other. There's a little, you just click on the little hand to raise your hand for questions. I know there were a couple of issues that came up last week. I wanted to get that email that I
Yes,
wanted to share. Yeah.
Yeah, Illuminata
I
has her
see a
hand up.
question from Illuminata.
Oh, I don't see the little, okay.
Thank you.
Hi, Illuminata. How
Since-
can we?
Hi, how are you?
I'm doing well, thank you. How are you?
I'm fine. I do have a question in regards to the witness and the copy of the ID. Question for the hospital. Do the hospital keep a copy of the parent's ID or witness? Number one. And number two, since I process my VAP through email, through mail or in the office, do I have to keep copies of the witness? And how are going to handle that with the witness that are signing and sending that to me by regular mail?
So you should be keeping copies of the ID. They can electronically send you a copy of their government issued ID. Most commonly used, as you know, is the driver's license. You can keep that on file for the ones that you're doing in-house.
Thank you.
So, Roseanne, what was the question that was asked last week of us? I think Ceci asked it. Do you want to ask that again, and so we can share it with everyone?
I can't remember what the question was.
And if I close the screen to go look at my emails, I'm afraid I'm gonna lose it. But I'm gonna look. I'm gonna try my phone. It was a good question. Ceci.
Ceci, you're on the line. Do you remember the question you had for us? You're on mute, Ceci. Ceci, could you unmute yourself?
Okay, I found it. I think sometimes if you're in your office and you don't have like we at the state can't do Teams from our office. We can only do it from our laptop. Okay, so the question was about the denial form from the spouse. And I was asked, or we were asked, if the denial, it was the responsibility of either vital records. Okay. Do you want to? Ceci, do you want to go forward, or you want me to continue reading this?
Oh, she doesn't have a microphone, Sharon.
She
They're
doesn't.
in chat.
Oh,
You see
okay.
it?
Yeah.
She said, seeing that we're expected to file births within 1 to 2 weeks, hospitals will attempt to question the delivering mother if she can obtain the spouse to sign the denial acknowledgement timely. But if the mother will have to go to the Department of Health with both the VAP but if they don't have enough time, they'll have to bring both forms to the Department of Health. I think that's what she's asking. Is that correct?
And that is correct. If they don't have enough time to do it before they leave your facility, that would have to be done here at the Department of Health.
So it's too bad that we don't have a procedure in place at the hospitals to send the whole packet to the birth mother before she gets into the hospital, so she can at least know what her options are, and she can maybe get the forms ready. But what was asked of us on December 31st was regarding whether it was up to Vital Records or the hospitals to obtain the denial form. And the way we answered this is that really it's up to the birth mother to obtain the denial form from the spouse. She is the one that needs to take the initiative, or the spouse needs to take the initiative, because by signing that denial form and submitting it, that spouse is or the presumed parent's being relieved of the legal responsibility for that child, and another person is taking the place for the responsibility of that child. So it's really up to them to take the initiative to move forward to get that denial form signed. It's not up to the hospital staff. It's not up to Vital Records staff. They really need to know, like any other procedure, what the forms are to do what they need to accomplish. So that's why I said it would be nice if these forms and pamphlets and everything were all provided before the admission, or even earlier at the OBGYN's office, and maybe we should explore that again. If there's no denial form received from the presumed parent, then as Roseanne said, that VAP may not be executed, and that presumed parent's name is going to go on that birth certificate. And unless they come later on and take, whatever steps they need with the denial form to do this. The other question that was asked, I think, was about the timing. So the Rhode Island Uniform Parentage Act went into effect January 1. So it's in effect. So if people come into the office after January 1, even if the child was born prior to January 1, the law is in effect, and you can go ahead and follow it.
We have a question from Michelle. Can you unmute yourself, Michelle?
Maybe it's in the chat. No. Oof. Maybe the question was answered.
Michelle, if you can't unmute your microphone, would you like to type your question in the chat box?
I wanted to just bring up a couple things just while we were waiting for that. So I think you might have mentioned this, Roseanne, but on your system, and we all know it's very hard to program and change things on a system. We know that better than most with the child support system. Even a word, we still have on our system, unfortunately, the word absent parent and client from 100 years ago. So to change that, it's very, it's expensive, it's programming, it goes with everything. You would think it would be very easy to do, but it isn't. So you still are using the term PA on your river system, but the PA is referring to the VAP.
It is. We're going to consider it a PA as a parentage acknowledgement versus a paternity acknowledgement. Okay. So the term is now parentage acknowledgement for the PA. Changing all of that would have cost a lot of money, where luckily we were able to leave that. We do have some other changes to the system that are underway. I'm hoping they get done soon. We only had 5 months to get these changes into our system. That was a challenge. I will tell you, they went in on December 31st.
Yeah. And I just have to tell everyone that the original effective date of this bill wasn't going to be until July, but both Roseanne and I were approached by the sponsors, and the advocates really wanted this in as soon as possible, especially during, a pandemic when people are having babies, unable to secure court orders, unable to get to court to litigate any of this. So we both agreed that we would work like crazy, and we did, to get this in effect, at least this portion of it, the voluntary acknowledgement of parentage. So obviously we're able to operate under the new law, even though some of the things still will have to be changed and programmed. And I will also tell you that it's turning out to be a bigger lift than we anticipated for child support as well, because there are a lot of regulations that are conflicting with this Parentage Act. And we right now really don't know, and I got a little bit of guidance from the federal government just this week, which really made things even more complicated, because we really don't know what our role is going to be with establishing parentage, the broader definition. Right now, we establish paternity, we get credit for paternity, that's the biological paternity, and so the regs really need some cleaning up. But it may be that we're going to have to be involved in some of these parentage hearings and procedures. I just don't know yet. We're still, so we got it in by January 1 for this portion of it, but we're still working on the child support provisions.
We also have some regs that need to be updated in accordance with this new Voluntary Acknowledgement of Parentage Act passing. Those are with the regulation department right now. Nothing happens overnight. Like I said, we were more concerned about getting the system updated so you could use it, and we'd work on the regs second and the statutes.
And we already know that there are a couple of provisions in this new law that really need to be changed. Some of them need to more closely mirror what we're actually doing, because they don't make sense. So there's 2 or 3 provisions, but that's not going to happen this year. Hopefully next year they'll be cleaned up. So no other questions? I thought we'd have a slew of questions this time. We can certainly schedule, wait a month or 6 weeks and schedule another, it won't be formal, but another sort of meeting Q&A session if you want to do that. But I would really appreciate if you would look over those pamphlets and let us know what else we need to add, what you think it's important, especially in that trifold, which is sort of a quick, easy way for you to get some answers to questions. You've got the manual, you've got the extensive Q&A from child support, but this one is just like a go-to. We want to make it as helpful as possible. So please let us know if we need to add anything.
So Sharon, there are a couple of questions in the chat box. One from Dolores. Is a copy of the ID required when the VAP is submitted to Vital Records? You can either keep it at your office, keep it on file in case we ever have to go to court, or you can submit it to us. That's an option for the facility. And Michelle was also able to type her question in. If there is a surrogate, then who would be parent number 1 and parent number 2 on the VAP? How is parent number 1 and parent number 2 determined? And do you need to copy both parents' IDs that are signing the VAP?
So I'll answer the first part and you can answer the second part.
Okay.
So if there is a surrogate at the hospital, and one would imagine that they would have already gone under the provisions of Article 8, they would have already gone before the Superior Court with their gestational carrier agreement, that's what it's called under the law. They've met all the requirements, and one would think that there would be a court order issued prior to the birth of the child, which names those two men, those two women, or that other couple as the parents of this child. So they would come into the hospital and they would present to you the court order, which names them as the parents of those children. That's what I would imagine under the new law that would happen. So you've got the surrogate. What's been happening for the past God knows how many years is if you have a surrogate and there's no court order, well, there's no one else's name that can go on that birth certificate except that surrogate at that time. But under this Article 8, this gives everyone an opportunity to do the agreement, follow all the rules that they're supposed to follow, and get that court order. And that court order would determine the parents. So I don't know, Roseanne, if there's two men or two women that are the parents of those child as declared by the Superior Court. Does it matter who goes in as 1 and 2?
It doesn't matter to us. It may matter to them. So, you know, if it's two men, I don't think it matters. I don't think it matters regardless of gender, I don't think it matters.
Yeah. Good question, though. I hope that answered it. And then she asked, and do you need to copy both parents' IDs that are signing?
Yes.
Yes.
Well, if it's a surrogate, that means it's a court order. So, you don't need a VAP, so you wouldn't need ID. But you should look at that ID for, you know, identification, proof of identification, to see that they are the people who are on that court order.
Yes, since they're going to be leaving the hospital with that baby.
That's right.
Yeah.
Now, it certainly doesn't hurt to keep a copy of the ID for yourself, but it's not required with a court order.
And then this one says, does this change who has access to obtain the record? I would imagine you want to know if they go to the Department of Health and they want a copy of the birth certificate or a certified copy of the VAP. She's asking currently who can do that? Who can we get a copy of that? The parents only.
The same, the parents only can get a copy. The parent number 1 and parent number 2 can get a copy of the voluntary acknowledgement of parentage. And so, and I guess when the child grows up, if the child wants it, other than that, that's it. Any other questions?
And maybe some of these questions will be added to the pamphlet. So we did provide you with the supply form. So if you are in need of any, you know, any of the pamphlets, let us know. I think on there, I think Shalika's name is on there, right, Rick, to request that. Shalika delivered all of the pamphlets this week to you. So thank you, Shalika, for doing that. And she's the one that will be getting a copy of your supply form. I can't believe there are no other questions. I'm happy.
Me too. Well, if you think of something, come up with any other questions, feel free to reach out to me or Sharon. Thank you so much for attending the final session of the Voluntary Acknowledgement of Parentage training. And we're here for you if you need us. Okay.
And these two, we already answered these two, so that's all set. Yep. Thank you for your participation. We really appreciate it. Have a great day.
Happy New Year. Bye-bye.
Yeah.